Hello, everyone, and welcome to The Rundown, where we talk about 2A news and conservative views. I am your host today, Craig DeLuz, coming at you from the West Coast, the left coast, behind the Iron Curtain, otherwise known as the Sierras. But as we all know, I do not do this program by myself.
No, my name is Mike Piorski. I come to you from the East Coast. That's the coast with the most from the co-host with the most here on the Rundown. 2A views, conservative news, and Greg, it's free for all Friday.
It is free for all Friday because, folks, look, we realized that we cut the week a little bit short on you because we Monday was a holiday and Tuesday we were recouping from that holiday, so we cut it short. So what we also thought we'd do today, we thought we would kind of recap because it's been a pretty big week, hasn't it, Mike?
Let's see. It hit 100 degrees here locally. They had some sales on the chicken sandwiches over at my favorite chicken store, and I had some tacos. So it's been a big week.
Yeah, I don't think any of that was like
What?
what I was referring to.
No, no. Oh, I'm sorry.
May have been a
I'm
big week
sorry.
for you in that aspect. I'm talking about in the news. I'm talking about issues that have been impacted and been in the news. It has been both entertaining as well as informative and somewhat inspirational, I might add.
Are you talking about Bicycle Gate?
I'm not talking about Bicycle Gate, although we will be talking about Bicycle Gate.
Okay. Okay. All right. Yep. I hear
Fun
they're going to
stuff.
ban those little tow holders on top of pedals on bicycles. They're getting rid of those.
Oh yeah, no, that's what I hear. That's what I hear. I heard it's actually going to happen via executive order.
Yeah. Yeah. Yeah.
Although
No one over
I think
80
what's going to
should wear
happen
those.
is that they're going to declare the 25th Amendment. Since Biden fell off his bike and is no physical condition to be president, I think
Yeah.
Kamala Harris is actually going to sign that one.
Last I saw, she was busy with Matthew McConaughey, but that was a different story.
Okay, that did not make that one did not make the family cut today.
Let's just say she was having a conversation with Matthew McConaughey to get him to talk about gun control. So that's
Exactly, kind of along the style that she had with Willie Brown, and we'll just leave it at that.
Oh, I didn't know that. Man, that's not what I heard. Family show, Craig. Come on, keep it family.
Family show. I just said family. Look, she was a good friend of Willie Brown's.
Oh, I bet he was. Yeah,
I'm just
I bet
gonna
she
leave.
was.
I'm just gonna leave it at that. I'm gonna leave it at that. For the family. Hey, so
All right.
folks, just real quick, housekeeping before we get started. Make sure if you're watching us, make sure you like, share, subscribe. Like, share, subscribe. A lot of our viewers are first-time viewers, so if you like, share, and subscribe, in particular on YouTube and Facebook, if you click that notification button, you'll be notified as soon as we go live, and you can participate in the live chat as the program is taking place. Just so you know, in case you haven't noticed. This program takes place 2 p.m. Pacific, 5 p.m. Eastern, Monday through Friday. So we're talking about stuff weekday in the
Yes.
afternoon/evening.
Yes. Yes. Except for the Monday, Juneteenth, Father's Day Monday. We usually take that one off.
I think that's really the only holiday we take off, right?
Yeah, that's it.
when
That's
they
the only one
fall
we took
together,
off,
when they fall together, that's kind of like
yeah.
okay, we got to take it off.
You have to, right? Yeah, yeah.
I think it's federal law.
It is. It is federal law. Yeah.
There you go. All right, let's start with the big news of the day. We've been waiting on the Supreme Court to rule on a number of things. Yesterday, we got a big ruling on the Second Amendment, which we'll talk about a little bit later. But the big one that a lot of people are looking at has to do with the decision on abortion or the overturning of Roe versus Wade. That's right. The Supreme Court has come out and basically said not only, well, first of all, they are making it very clear. They are not overturning or they are not eliminating the constitutional right to an abortion. Mike, what they pretty much said in this decision was, no such constitutional right ever existed.
Right. And this is what you and I have been saying for years and years. We've probably said it here on the radio show is that, here's the document. Show me the constitutional right. And they overturned Roe and they overturned Casey. And I think the important thing to think, Greg, is that they did not outlaw abortion. And that's what everybody's going to say. They did not outlaw abortion. They've simply returned it to the states and said, this is a states' right issue. Your states, your governor, your legislators, you decide what the law of your state is.
Oh yeah, that was the most important thing, and I think that will be overlooked. The most important thing that will be overlooked in this decision is the fact that in essence what they said was, look, if you in your state constitution, if your state constitution decides that you believe it's a right in your state, then it's a right in your state. It just does not arise. It does not arise to the level of a constitutionally protected right because such a right is not conferred in our Constitution. They said they got it wrong. And Mike, we were talking a little bit before the show. I don't want to steal your point. Why did they say they got it wrong?
Listen, there are many reasons, and this is a very, very long, ruling.
Over 200 pages.
The first example they cited was Plessy v. Ferguson, and for those that don't remember that, that's separate but equal when it came to the schools. And they said, listen, we've gotten things wrong before. We got Plessy v. Ferguson wrong before, and that was because it was accepted at the time. That was the next step. It looked like the right thing to do. Going back and taking a look at it, though, that court did not follow the constitutional standard, and it's as if they gave in to the the pressure of the nation at the time, and that's not what the court's supposed to do. So they went back and said, listen, we should have made it at that time all people were equal, but we didn't because we were afraid what would happen. All right. And they said that's wrong. So here we are. We're now correcting another wrong that the court has. The court did not follow through on their decision or their theory, the stare decisis, let the decision stand, the previous precedents. So, they got it wrong. And they said, in Plessy versus Ferguson, and they said, that's the same thing with Roe v. Wade and the same thing with Casey. Casey didn't examine the right set of facts, which Casey was the reexamination of Roe v. Wade from back in the early 90s. And again, they said, that they got it wrong.
Well, and that's one of the biggest challenges issues I've always had is with this issue of quote unquote stare decisis, or, basically precedent. It's not that I'm against the idea of precedent, but if precedent is not based in law, if the foundation of the precedent is wrong, then that
Correct.
makes the decision wrong. And at a certain point,
Right.
you have to be willing to go back and correct it. The thing about this particular decision that I think that makes it even more important is because this is a fundamental question of really, quite frankly, when life begins, right? Because
Yes.
if you believe that it is a life that is in the womb, then that is a life that has a right to exist and a right to be protected. And we now know so much more scientifically we have a lot more information and data as to when life begins or what the various stages of gestation are. We have a lot more information now to make a much more informed decision. And the problem was Roe v. Wade and Casey made it impossible to have that discussion because they're like, no. Constitutional right? Nope. Can't even converse. Can't even talk about it. Well, now, guess what? We can now talk about it. We can look at the science. We can look at the information, and hopefully in state legislatures and amongst political pundits and amongst academics, we will actually start to have those sorts of conversations in order to determine what sort of regulation or restrictions should exist. And that's really what they said. They said, look, we now give it back to the states and the people of those states to regulate this particular function.
Yeah, in Roe v. Wade, they did not discuss the viability of a child, of inside the womb, outside the womb. When could the child survive? And like you just said, you're talking over 50 years ago, and so 50 years in medical advances. So that having never been defined before, this court found in error, and now 50 years later, we know it's going to move that line, right? We see these stories and hear these stories every day of for whatever reason a child being born prematurely and living a healthy lives. The other thing it looked at along there, Craig, was what they call the what was their term they used for the quickening, pre-quickening and post-quickening. as well. So a lot of stuff that wasn't looked at, and then in Casey, they should have looked at viability and they didn't. They ignored that as well. So
Well,
again, this court comes along
they,
and says
mhm,
previous courts got it wrong, and
right,
it's not illegal. Let's make sure we understand that
right.
it's not illegal.
Well, in various states do have restrictions on abortion. I don't know that any
Right.
have just an out and outright ban. I think there's at least one state that makes it illegal unless it's to protect the life or the health of the mother. But most states, in almost every state, there is at most a restriction, meaning okay, only after a certain number of weeks, right? Only before a certain number of weeks. But
Yeah.
talk about the science. This is a lapel pin. I don't know if you guys can see that. Let's see if it'll zoom in at all. No, it doesn't appear to want to zoom in. But it's like those are like supposed to be the size of the feet of a baby at 6 weeks, right? The whole point of that is that a lot of pro-life activists wear that pin, but science is what has allowed us to be able to know that information, to know when there is a heartbeat, to know when there is brain activity, to see when there are limbs, and know when it is in fact, and once again, give us more information as to when life begins. And I think it's important for us to once again have those conversations. We need to have those conversations because in the end, we won't. I'm thinking this: if there's a chance that it is life, we want to get this decision right. I'm always going to decide to err on the side of protecting innocent life.
You're absolutely right, Craig, and it all comes down to the medical science, and this is going to come down to, again, like we keep saying, down to individual states and states' rights. And I'm going to tell you, I think you're going to be surprised. This is not going to be such a clear red and blue state issue.
Yeah.
The lines between what your mother and grandmother viewed, what was morally right and what was a sin, are changed greatly today. It's not as pressing an issue it is for the youth of America as I think it was back then. So it's going to be interesting to see. I'd like Florida is. I'll tell you, for instance, Florida's we know that's a clear red state at this point, right?
Mhm.
Well, listen, there's abortions are legal in Florida. It's
Right.
never, they've done some limiting, but I think Florida's a 24-week, not a 15-week, if I recall.
Right.
So I think you're going to be surprised at what you see.
Well, I think first of all, if you look at the polls, there's a place where I think most people fall. Overwhelming majority of people fall. Number one, most people believe that abortions should be legal, but they should be restricted, generally within the first trimester, or to protect the life and the health of the mother, or in the case of rape or incest. That
Right.
gets you the overwhelming majority of people that's where they fall when it comes to abortion. Now, I'm not saying that there aren't people who believe it should be less restrictive, because there are, and there are people who
Right.
believe it should be more restrictive. There are.
Right.
But in the end, I think that we need to take a look at the data, take a look at the science, and then arrive at a place that I think works for where you live, for the values of the culture and the community in which you live. And my thing is this: if you disagree with the culture and the values of the community in which you live, then maybe you should consider finding a new community. I'm just saying.
Yeah. Yeah, absolutely. Absolutely right. And listen, again, we're talking 50 years changes in medical science, right? 50 years
Yeah.
changes in medical science. Back then, Craig, if you wanted to determine if you were pregnant or not, remember the old saying, well, the rabbit done died?
Right.
Well, they used to have to use certain organs from the rabbit to determine if you were pregnant or not. Now it's you can get the old pea on a stick at the dollar store.
Right.
As you could get them there. How about not knowing the sex of the baby until the baby was born, and now you can get full 100% digital imaging of your child before they ever leave the womb. It's just
Right.
the medical advances are ridiculous now compared to what we had back then.
Which is why it's so important, once again, that we have those discussions. So
Exactly.
hats off to the Supreme Court. And once again, I believe they've gone out of their way to fully, once again, this is an over 200-page decision. So it is impossible for us to give you a fully exhaustive analysis of it right now. But I would encourage you, over time, take the time, listen to the legal experts on this, and get an idea of what they're saying. And by the way, the legal experts that you agree with and you disagree with. And here's what I can encourage you to do. Listen to the law. Don't listen to what they say their moral justification is, this right or wrong. Take a look at the law where they cite what the Constitution means, what they cite, to look at the law, because in the end, the Supreme Court's job, the court's job is to interpret the law, not to write law, not to create law, but to interpret the law as it pertains in particular to the Constitution of the United States.
Yep, there you go.
Anyway, moving right along, you guys know that we just had a recent decision relating to the Second Amendment. That's right, that noted that the right to keep or the right to bear arms, well, it exists outside of the home, believe it or not. Yeah, I know. And the left is, quite frankly, losing their minds. This is a piece. I mean, they are literally flat out losing their mind, whether it's the governor of New York, whether it's the folks there on the governor of California who has lost his mind. They are basically referring to Clarence Thomas's maximalist Second Amendment ruling is a nightmare for gun control. Now, the one part I will say is, yes, it is a maximalist, because guess what? Shall not be infringed means shall not be infringed. So I think you should go to the maximum on that. And yes, it is in the end going to be a nightmare for gun control. Mike, yesterday I had a chance to host with the Firearms Policy Coalition. Last night we hosted a symposium. It was almost an hour and a half with 4 legal scholars who are experts when it comes to Second Amendment and Second Amendment issues and legal decisions. And I got to tell you, man, calling it a symposium doesn't even really do it justice. You know me, I like to talk, and all I could do was sit and listen. I was guiding traffic. That's all I was doing. But they were dropping bombs on this. And this decision that was made is going to have an impact beyond just the right to carry a firearm.
Sure, well beyond it. In fact, I did a program yesterday afternoon too with an attorney as well, and it's always good to be placed with an attorney. Obviously they have the law degree behind them and that fundamental knowledge. So it's always good to supplement and add to what each other have to say. So that's a nice thing. But Craig, I think a lot more is going to come out of this. I think this is we'll find that this maximalist ruling, by the way. We'll cover that in a moment. I want to make sure we come back to that. But we'll find that this extends beyond what we have here. One of the things we looked at yesterday, I think you and I mentioned it as well, was Craig, you're in California. I'm in Florida. I now have the right to have my firearm outside my home. Well, outside my home would include California as well. So do the justices, having specifically not mentioning interstate travel or reciprocity, did they leave that door open for the next ruling on this on purpose?
Well, I think they did, because I think they want to see how it eventually will manifest. Yep. Because obviously under the 14th Amendment that there's going to be an issue. Under the right to interstate travel, that is also going to be an issue. The question is, are the states going to work that out? And I don't think the issue is going to be with the 43 states that are currently shall issue. I think the issue is going to be with the 6 states in Washington, D.C. That are may issue. I think that's where you're going to... Yeah, because they're going to have to say, okay, look, they're going to get sued, and they're going to have to determine, okay, are we going to allow people to get our permits? Are we going to recognize other states' permits? If I were California, quite frankly, what I would do is I would be open to the idea of reciprocity if your permit met our standard.
Well, and that's what the problem has always been, is that your permit must meet our standard. Well, if your standard has been may issue, well, that doesn't meet their less examination standard of shall issue. I'm sure less objective.
Well, I mean, exactly. Well, what they're referring to mostly is, okay, what I'm referring to is, okay, well, you've done a background check, you've done X amount of classes, now I'm not saying that I advocate for those things. I'm saying that the state of California, if I know our leaders to be who they think they are, they want to be trendsetters. And so they're going to want to lift the standard for concealed carry permits for the entire country. Now,
well, right. And I know what you're saying is California requires what? Is it 4 hours or 8 hours of training
for
to
your
get your license?
for your initial, I believe it's for your initial, I believe it's 8 or 16 hours training.
Okay,
It's
so
two. It's
your
basically
state,
it's a 2-day class.
so I'll go there. Your state requires 8 or 16 hours of training.
Right.
Florida requires, I'll give you this, Florida requires training.
Right.
That's all it says. There's no minimum time. I've seen the classes taught in 45 minutes. The only thing that they've specified on the administrative level is they want you to pull the trigger on one live round, which has resulted in, Craig, by the way, shooting 22s with a suppressor into a bucket of sand. So that's the training. Here, how about Georgia? No training requirement, constitutional carry state. Okay.
Right.
So here's the problem, right? Now the law says I can carry my firearm outside my home. It does not say I can't carry how far outside my home. It says I can carry outside my home. So I think the states now are going to have to, they may want to wheel and deal about your standard is my standard and whose standard is up to which standard. But I think they're going to have to accept right now that if I decided based on this amendment from yesterday, this constitutional decision from the court yesterday, that if I'm in New Jersey with a firearm that has been granted to me to be carried under a shall issue statute, I've met the Supreme Court's burden of proof right there.
Well, I think the argument is going to be that what may happen is states like California may make it possible for out-of-staters to get a California permit. They may require you to come to California to apply for it. Basically, they're going to make it really difficult for you to be able to get it.
Right.
But it'll be possible. If you want to carry in California, here's how you do it. And so they'll make it available, but they'll make it either cost prohibitive or just very difficult administratively for you to be able to get it. That's what I'm guessing is going to wind up happening.
Which means we go back to court.
Right.
And then California gets spanked down again. But until that law, until there's another provision that allows me to go through a process to get a California permit,
right,
I'm saying as of this moment, I'm qualified to carry a firearm in California.
Well, yes, but what I will tell you about the state of California is they really don't care what the Constitution says because they know what will happen. They know that in the Ninth Circuit, they know that regardless of what the law is and what the Constitution says, they know they'll win in the Ninth Circuit. And they know that it will take, decades for you to finally get to the Supreme Court and for them to lose.
Right.
That's.
No, I agree. I'm just, in theory, in legal theory,
right.
I can go to New York City, I can go to New Jersey, I can go to California right now, as long as I have a permit that's been issued under the shall issue standard. And I don't meet any disqualifying offenses, which I wouldn't because I would have the permit. Then that's outside my home. I choose to carry outside my home. I just happen to be in Trenton, New Jersey today. That's all.
Yep. Nope. I hear you. And I think, like I said, I think what you'll see is you'll start to see a lot of states I think a lot of other states are going to start to make it so they're going to start recognizing other states' permits, and it's going to start to make it a whole heck of a lot easier. California, New York, Rhode Island, New Jersey are going to be the lone holdouts. And sadly, the taxpayers there are going to foot the bill for the legal challenges because they're going to lose.
Yeah.
And,
you are correct.
They're going to wind up losing. So anyway, it's real interesting to see. Now, you said you wanted to touch on the whole maximalist thing, a statement that they made regarding.
There's a saying in the Second Amendment industry, right, that says all gun laws are unconstitutional. Craig, you and I, we've had this conversation before. I'm not that guy. I don't think that all gun laws are unconstitutional. I think 99% of them are unconstitutional. But I'm pretty clear because I've done things like my own research. I've read the Federalist Papers. I've read the personal letters of the founding fathers, and they never meant for felons or for the mentally incapable, incompetent, or minors. And I'm not talking minors like they had 14, 15-year-olds back then, because those were adults back then. I'm talking like a 4-year-old can't take a Glock to pre-K. All right, that would be a crime. A crime against the parents for allowing that to happen, but not because a 4-year-old can't process intent in its brain. But there are some laws that are constitutional. You can't let people that are disqualified from having firearms, let them have firearms.
Well,
that there's still some
right.
unconstitutional laws out there. There's still some laws against firearms that are constitutional.
Well,
I want to see NFA
yeah.
gone. I want to see the National Firearm Act gone.
Yep.
I want to see the 86 Gun Control Act gone.
Right.
All of those are restrictions on law-abiding citizens. Okay?
Well, just one clarification. Their definition of felon is very different than the definition of felon today. Their definition of felon were individuals who were guilty of a violent crime, right? Violence against, in particular, violence against others. Now, you can, if you write a bad check over a certain size, you can be convicted of a felony and lose your rights. That, too, is something that the founders never actually intended. There are also...
It's something that the founding fathers never had to deal with. They never had a white-collar crime. They never had a guy bilk, $2 million out of an old person's, saved life savings. They never had that happen before because it wasn't a currency-based system. Remember, it was a barter-based system. We had currency, but you didn't need currency to live. You needed, supplies and goods.
The sort of justice that would be meted out for doing something like that was a little more swift.
Well, yeah, and they wouldn't have to worry about carrying firearms because they would have cut their hands off.
Exactly.
Doing something like
they would have had no. They would have had no arms to bear.
Right.
To bear arms. They would have no arms to bear arms.
If you were convicted of a felony back in 1776, you just went away. There was no, I'm going to give you 3 to 5 with good behavior. It was, bye, Johnny. We'll see you at your grave. You didn't come back from jail. You were just sentenced to jail. And the minor ones, you got the public floggings or put in the locks and stockades to teach you a lesson that maybe you could be rehabilitated. But if you were convicted of a felony, bye-bye. You went away. So they didn't have to deal with felons with firearms back then because felons were dealing with trying to stay alive back then.
Yeah. Well, there was also a lot less crime at that time because, well, if you got caught, there were actual consequences as opposed to what takes place today.
Yeah. Right.
Hey, Mike, wanted to go back and just kind of do a recap. So we did we talked a little bit about Juneteenth and about kind of the various different things that went on during Juneteenth. And for those of you who do not know or don't remember, the Vice President of the United States actually gave us a history lesson talking about the 400 years of slavery. And I'll let you check that out real quick.
And to think about it in terms of the context of history, knowing that black people in America were not free for 400 years of slavery, right? And to think about it in terms of the context of history, knowing that black people in America were not free for 400 years of slavery.
That's right. For 400 years of slavery, black people were not free.
Listen, 127 years is from inception of this country to Emancipation Proclamation, 130 from inception to the last piece of the Emancipation Proclamation, making it to Texas on Juneteenth. All right, that's why Juneteenth is there. She's an idiot. She's a moron. We all know that. I almost hate talking about her just because of I feel bad, speaking bad about a woman, an elder woman like that. So
older woman.
Well, she's old. You're supposed to respect your elders, right? And she's an idiot. I don't know what else.
It's hard to respect. It's hard. It is definitely difficult to respect someone who is just not that bright or just says very stupid things. I mean, I got to imagine she can't be a complete idiot if she got a law degree, although it is from California, so you never know.
She's a prime example of, and we see this in the training industry all the time, the Dunning-Kruger effect. If you're not familiar with the Dunning-Kruger effect, it means that you believe your skill set is so much higher and that you're so much better at what you do than everybody else because of your believed that you have the higher intelligence or the higher skill level or the higher training level than everybody else. She has the Dunning-Kruger effect for politics. She thinks she's the master at all of this, and she's an idiot. And she's an idiot. She walks around high and mighty, condescendingly talking to people, and she's the dumb one. So she's a prime example of that.
That's what makes her stupidity so much even more obvious is that she honestly talks down to people like she thinks she's so much smarter, right?
Yeah.
When she slows down and
Yeah.
speaks to people, like,
Yeah. That's
you're
it.
an idiot.
I'm speaking now. Okay. I'm
speaking
speaking now. I'm speaking now.
Do not mansplain
She,
to me.
she, uh, the other thing here, they said, Craig and I encountered it a couple times this week. I don't know if you did. When talking about Juneteenth, I'd get an anti a black sentiment. I'd get a racist statement from people. They'd refer to it like the MLK Day, which
Right.
is a celebration of. By the way, again, wrongfully done. Martin Luther King was a Republican as well, who brought freedom and equality
Right.
to everybody. He's one of my top 5 heroes of the 20th century. But the same thing with Juneteenth, that I had to stop and explain. Hey, this is a Republican victory celebration dance. Okay.
Yes.
The day we have off today is because Republicans went and finally gave the last piece of the last spreading of the Emancipation Proclamation to those in Texas who had been oppressed from hearing it before, because remember, Texas's involvement in the Civil War was minimal.
Right.
So they wanted to keep their slaves working. So they did so until Republicans finally showed up after the war and went, wait a second, hold on. No, you're free now. And they were like, what? Republicans freed Democrat slaves. That's the celebration of Juneteenth.
It was literally the first step in making the promise that was in our Declaration of Independence, the promise that was in our Constitution, available to all people. It was the first step. And there were other steps that still needed to be taken. But let's be clear, Republicans were the ones, a Republican president. By the way, the first Republican president in a party that was founded specifically to accomplish this goal. So I'm like, any Republican, it's like, look, no, I get it. The left wants to pervert what Juneteenth is. They want to talk about George Floyd and this, that, and the other. No. That's not what it's about. It's about that recognition, right? And that step started us off on a path. And are we where we eventually want to be, where we totally want to be? Have we reached the end of that path yet? No, we haven't. But we are so much further along on that path than the left want to give us credit for. The critical race theorists, the Black Lives Matter folks, they want to act as if slavery never ended, right? They want to act as if we're still living pre-Jim Crow. And that is just a flat out lie. And what we need to be doing is utilizing Juneteenth as an opportunity to show that, to lay that out for the world to see, to anybody with a thinking mind to be able to see.
Yeah, Craig, listen, I think I think the racism issue is worse now than it was 12, 13 years ago. I'll say 12, 13 years ago, we were all sitting pretty good, pretty equal. And then we ran into an eight-year wall of racism that got put down our throats.
Well, but here's the thing, though, folks. Here's the thing, though. It didn't come from conservative white people. I'll tell you who's pushing it. It's liberal Marxist socialist white people. Yeah. That's who's pushing it. And you have a lot of people in academia. A lot of them are black academics. Yeah, you got the black academics who are the ones that are pushing this. And the worst part about it, Mike, is that the whole goal of all of this is to destroy the very same country and the very same values that have propelled us forward in trying to promote equality. Because they don't want equality, they want equity, meaning they want to take from one group to give to another, right? They want to institute racism in order to solve racism.
Right. Make sure your folks understand what Craig said. Equality. Equality means we have the right to earn the same. Equity means you want to divvy it up and give it to all as an equal share.
Equity is this idea that in concept, you think, okay, we're going to give to those, as the socialists put it, we're going to take from people out of their abundance and give to those based on their need, right?
No. Yeah.
And that's not equality. Equality is I'm going to give you an equal. Everyone's going to have an equal opportunity to be able to succeed, right?
Yes.
And we're going to get out of the way and allow you to succeed and remove artificial barriers. That's what equality is. Now, once again, have we hit equality yet? No, but we're a lot closer than we were when we started. And 50 years from now, we're going to be a lot further along than we are now.
Yeah.
But to act like we've gotten nowhere. In fact, to push it backwards by saying, "Hey, hey, you white people, yeah, you are oppressors because you're white, and black people, yeah, you're oppressed, yep, because you're black, and we're going to take from you oppressors, and we're going to give to you who are oppressed because we are the government, and we're the only ones that can right wrongs."
Yep, absolutely right. And, no dispute, no dispute.
Anyway, so that's all the once again the Juneteenth follow up. Just wanted to kind of express our opinions on that one. We got another one. Now, this is actually a news story. This is one we have not talked about. Mike, you want to introduce this particular story to folks?
Well, this happened. We were doing a weekend wrap, but this happened, yesterday. So we've got to put it on here. The president once again got caught with his cue cards, and now you think of cue cards like I do it, Craig. When I speak, I'll take a notepad, put 4 or 5 words on there, and I'm good for an hour. Just make sure I hit my high points. Well, the president, his cue cards literally tell him things like, let's show you how deep, and they have what they have to tell him. Craig, if you'll scroll down here a little bit further here, beyond that picture, it tells him, you enter the Roosevelt room and say hello. You take your seat. Press enters. See, that's the start. That's the start of his speech right there. Okay, so he can read his prompter. You give brief comments. Press departs again on his teleprompter to stop. You ask Liz Schuler a question. Note, Liz is joining virtually. Okay, this is what you do to somebody who is mentally deficient and cannot formulate their own thoughts. This might as well say, you eat the sandwich, you wipe your face, you go to the bathroom. This is how basic these things are. He is just a puppet up there.
It is exactly what it is. And by the way, those comments or the comments that are there were on, once again, like you said, on a teleprompter. They weren't necessarily on the cue card because you can't have him reading from the cue card. He has to look like he knows what he's saying. But we also know that when he reads the teleprompter, Lord knows what is going to come out of his mouth.
Right. Now, like it says there, it has enter to start the teleprompter. And I'm betting the last line on a teleprompter says, go back to the cue card.
Which, by the way, okay, so let's move on to our parting shot. By the way, and this is also kind of part of for the Juneteenth weekend. We know that the president of the United States, well, let's just say, if fixing the economy is like riding a bike, we got a problem because we had a president go down this weekend, fell off of his bicycle, not while it wasn't even moving. All right, he was trying to get off of it and fell down. Which, by the way, is just a metaphor for the difference between him and his predecessor, which pretty much is spelled out in this particular parting shot right here. For those of you who are just listening, you've got Biden on the ground with his little bike helmet on, and he's fallen down, and you've got Trump standing on the seat of a motorcycle, popping a wheelie, no helmet in hand. It's hilarious. Now we also got a couple of things here that now this next one is related to both the Second Amendment as well as to the January 6th committee. For those of you once again who are listening, it's the meme with the person trying to make a decision between two buttons and the person underneath being Democrats sweating. And one button says, your AR-15s can't win against a government that has F-15s and nukes, right? That's when you talk about, the Second Amendment is about, a tyrannical government. Then the next one, it says, protesters with bats and bear spray almost overthrew the government.
You can't have both, folks. You can only have one or the other.
Right. It's one or the other. But you're right. You do not get to have both, and Democrats can't figure out which one it is. All right, this last one. Well, this is kind of an AFT comment, shall we say? Right?
AFT.
This shows you how stupid some of the, or how off some of the opinions are, or the policies or regulations of the AFT or the ATF actually are. All right, so this has got Patrick from SpongeBob SquarePants. And what's that other guy's name? He looks like a manta ray. I don't know that character's name. Do you? No?
Oh, I know. I have no idea what that guy's name is. Yeah.
Okay, well, anyway, he looks like a manta
Evil
ray, and he's holding
Yeah.
an AR-15, an AR, and he says, "Is this legal?" And Patrick, wearing an ATF hat, says, "Yep." Then he has, and this
Then he
is
shows
legal?
him an AR pistol.
Right. And he says,
"Is
Yep.
this legal?"
He says, "Is this legal?" Yep. So I can combine these. That's a felony. That makes no sense. I've already shot your dog, is what Patrick says. All right, do us a quick favor, Mike, because for people who don't necessarily follow the ATF, do me a favor and tell them what is the point of talking about shooting the dog.
Well, let's be sure what we're talking about here. These
Right.
you have your standard AR-15 long barrel front and a collapsible stock. Then they showed a pistol. Pistol has a short barrel front and a pokey stock, just a tube out the back, no stock. And then they had the combination. They had the stock for the bottom for the rifle and the short barrel for the pistol. Well, now all of a sudden it's illegal and shooting your dog. The ATF thing, right? Listen, that's what they did in Ruby Ridge. It's what they did in Waco. And I'm not talking about anybody's opinions on whatever you do there, but it seems the ATF, their first goal anytime they go somewhere, anytime they do a raid, is to shoot the dog. And it's happened so many times that it's become the lexicon of the ATF. It's the I'll shoot your dog.
Well, and you only know this if you follow these particular instances. And I'll be the first one to say I won't necessarily get into the legality or anything, whether it's Waco or any of those. But what I will say is this: to shoot a dog is, I mean, really.
They make, I'll tell you what, Craig, how ridiculous it's gotten to the point that ATF's just known to shoot your dog is there's a dog leash out there, and somebody made a dog leash that is called the ATF dog leash, ATF training dog leash. And it's the dog leash, right, with the lead. And instead of it coming out like a return reel, the return reel is a pretend Glock. So the return reel has a Glock. So you're always pointing down the leash at the dog.
That is horrible. That's funny.
Yes.
All right.
Yes, it is.
Hey, Mike, you know what? We're way over time. So let's do a real quick shout out to our sponsors.
Let's see. Let's talk about our good friends at Guerrilla Machining, Grid Defense, the California Republican Assembly, and then, of course, our good friends at uscombatgear.com.
That's right, folks. Once again, their links to their websites are in the description of this video. Check them out, give them some money, and let them know that the guys over at The Rundown sent you. With that, we are going to bring an end to a stupendous, though short, week. And we really appreciate you guys tuning in. We appreciate you liking and sharing and encouraging your friends to do the same. I hope that you will have a fun and safe weekend. And who knows, maybe you'll get a chance to send a few rounds downrange.
What do you mean, like artillery rounds? Like red leg, fire mission over.
On that note, we'll see you on Monday.